Good morning. Hello, everybody, and welcome to Talking Risk in webinar format. Today, we're going to be talking about COVID-19 and some of the potential litigation that could come out of the pandemic. Just before we start, for those of you who've logged on, if you're seeing the video window as being quite small, you can enlarge that to make it easier to see our panel today. Maximize the button at the top right or click and drag at the bottom right. Thank you. So to introduce myself, my name is James Murray, and I'm one of Gallagher's UK branch directors. And perhaps for those of you who may be less familiar with Gallagher, we are one of the world's largest risk management, insurance broking, and consultancy firms. I'm very, very pleased to be joined today by my colleague, Neil Hodgson. Neil is Managing Director of our UK risk management practice. And he's also chair of the Northeast Institute of Risk Management. And I'm also very, very pleased to say that we have not one, but two partners from leading national law firm Mills & Reeves. We're joined by Ben Hardiman, who is a specialist in professional indemnity and construction litigation. And Ben also advises directors and officers policyholders like yourself in really quite complex and high value disputes. And also from Mills & Reeves, we're joined by Andrew Secker. Andrew is an employment law specialist. He's an expert legal commentator, and he advises national and international businesses on complex labour law challenges. So to give you all a little bit of context about how we came up with the topic for today and what it's all about, what we were thinking about was all of those critical decisions that you and your business have made over the past few weeks to respond to the COVID-19 pandemic. We're thinking about those critical decisions and the variety of groups that those decisions have impacted. And we're also considering the huge amount of pressure that you and your boards have been under: time pressure, legal obligations, moral obligations. And what we'll be exploring today is how actions taken and decisions made during the pandemic could, just potentially, expose you and the business to potential litigation. And I think we can probably summarize that as being actions brought by employees, potentially actions brought by shareholders, investors, regulators, and then also the potential, perhaps, for action that could be brought against individual directors. We absolutely do not intend to go through every single exposure with you. That's not possible. Instead, our panel of experts are going to be sharing a few thoughts and insights to give you a challenge and perhaps promote further debate within your own businesses. Format for today is we're going to be doing a little bit of a Q&A with the panel. I think that will probably take 45 minutes. I'll try and keep to time. If we run over a little bit, we will, but we'll try and keep it roughly on time. And then there'll be an opportunity for members of the audience to ask questions. If you'd like to submit a question, simply at the bottom of your screen, use the Q&A button that will access the chat function. Alternatively, there's an envelope icon. If you press on that, you can send us an email, but we won't be responding to the emails until after the webinar. So when we normally run Talking Risk, we do them in a room. It's a face-to-face event. We even put breakfast on, and it's about this sort of time that I tell everybody where the facilities are and how to access them, and I let you know if we have a scheduled fire drill for the day. None of that applies, but this is a new experience for all of us, the new normal of working remotely. We've got speakers in different places, working from bedrooms, living rooms, offices. So I just want to make it clear that we need to accept the fact we could get a rogue toddler. We might get a pet. We could get a doorbell ringing. If those things happen, they happen, and we just move on. The final thing I wanted to say before I turn to the panel is that there is a 1 minute silence at 11 a.m. today. The 1 minute silence is to acknowledge and respect those key workers who've regrettably and sadly lost their lives during the pandemic. If we are still online at 11 a.m., we will be observing the 1 minute silence, and then we'll pick up afterwards to close the webinar off. So I think we can all agree that's plenty of talking from me. So what I'd like to do now is perhaps turn to my colleague Neil and ask Neil, so COVID-19, as the crisis continues, and based on your experience and the interactions that you're having with clients, what are some of your key concerns for businesses?
Super, thanks, James. Good morning, everybody. Yeah, we're obviously all here this morning, so we've managed those initial stages of the pandemic and obviously reacted in the best way possible. But actually, it's looking forward now, isn't it? It's remembering actually that health and safety just doesn't stop because it's unprecedented times. Its importance potentially is greater now than ever with all the new risks that we face. So actually, I'd probably look to cover off 3 key areas to highlight today, really, and that would be injury to colleagues and their families, the action from the regulators, the HSE, and actually looking at managing a safe return to work as well.
Okay, Neil. So the first thing you mentioned there was the injury to colleagues and potentially their family members. I appreciate that, there will be a number of people who regrettably do lose their lives from COVID, but for many people, I guess it's a few weeks of kind of illness. What's your concern here in terms of injury? Is it people catching COVID and being off work for a few weeks? What's your concerns?
All right, thank you. Well, I mean, it doesn't matter if you're a fully operational business, a skeleton staff business. Obviously, you've identified those workers which have stayed or have been furloughed indeed, but it's looking at what impact that's had. In either scenario, really, a colleague or a family member contracts the virus whilst actually employed by you. Now, whilst proving causation is always going to be difficult, how do you as a business show that you haven't been negligent or made an omission, which has actually led to them contracting that? Long gone are the old days of a physical injury needing to be evident for a claim or a prosecution to be successful indeed. Stress and mental health have become increasingly prevalent in the last few years, and, a major contributor to absence claims and all the costs that are incurred around there. And it's the judgments that have been made to ensure your business continues to trade that we need to look at. And are the staff stressed with being made to work in what they perceive to be a non-essential business, for instance, or one that actually they don't believe is looking out for them? Only last week, the Parliamentary Committee said it received over 2,000 emails from workers concerned about lack of PPE, hygiene facilities and social distancing measures at their employment. Now, it doesn't matter if they're unfounded or spurious. This could be costly in your time, but ultimately also your insurer's time and the money that's spent in trying to defend those actions. There's also the additional financial impacts that can have by way of brand damage. If we look social media, which obviously everybody's doing a lot of at the moment, there's a lot of big names and some serious scrutiny from the public for trying to do the right thing, but not necessarily doing it the right way.
It's interesting you say that, because I guess, there's certain things which are perhaps hopefully more obvious to businesses. There's the risk of COVID creating large numbers of people being off in the workforce at any one time and the impact that can have on the business. But I think it's easy to think about, well, if people are off and they're off for a couple of weeks, and hopefully most people have quite a minor reaction, the potential for claim is relatively small in terms of financial impact, quantum and likelihood. But what you're saying there about the mental anguish and the stress element opens up a whole new dynamic on that. It's interesting as well. So I was just saying, it's interesting what you mentioned about the fact that people are actively reporting their employer to the HSE.
Yeah, no, I mean, we're hearing that quite a lot now, that the HSE and local environmental officers are acting from reports from aggrieved or disgruntled employees, rightly or wrongly. And, they've decided that they will issue enforcement notices for not adhering to social distancing, even though, and this is the interesting bit, I think, that even though it's a Public Health England guidance and it's not actually health and safety legislation, you've obviously got on the back of their, unionised businesses as well, and I'm sure there's a few on the line today. Union members are being asked to be looked after in obviously the same sort of way, but the unions are actually wanting to understand what those certain actions look like. See, and the unions issuing joint statements just last week and the week before, which again is quite unusual. And I suppose the question to ask yourselves is actually, can your business offer that robust defence to these questions? Is your occupational health in overdrive? Are the precautions in place?
So I think you could forgive some businesses for thinking, wow, we've been through the mill, we continue to be going through the mill, we're barely getting back on our feet, and to perhaps think that the regulator might give them a little bit of breathing space. But you've listed that as one of your second of your three key concerns for business. So it sounds like the message from you is that relaxed approach and breathing space certainly isn't going to be there.
I don't believe so, no. I think ultimately, the HSE obviously have a job to do, and it's not beyond the realms of possibility that they will investigate individual RIDDOR claims. I presume everybody's aware of reporting of injuries and dangerous diseases regulations, and look to bring proceedings against employers for exposing their employees to the risk. Now, obviously the prosecution depends on all the facts of the case and the extent of the evidence available. But actually, when you look at the number of unfortunate deaths within the medical and care workers sector, allegedly, and this is via media, of course, insufficient or lacking in the correct PPE, then actually is that workplace, being affected because of those reasons? That could actually then set precedent, and that, of course, leaves the door open for many, many other sectors. I know this weekend lots of retail businesses in a certain manner. This, potentially, could, start getting, quite a few legs, if you like. So how you submit a RIDDOR report actually could have a really major impact. A poorly written submission could actually instigate that regulatory investigation. The HSE, like everybody, are working remotely, and that's, they have to balance the risk towards their staff as well. But I think what it will allow them to do is look at preliminary investigation in much more detail. Obviously, they're travelling less and spending much less time on the road, so more interviews are going to be possible over the phone or by video conferencing like today. And of course, that will allow them to make a much more informed decision as to whether they take the matter further.
And so, of course, the key thing of this always is to keep people safe. But for me, the consideration for businesses, the new situation with RIDDORs in terms of reporting COVID-19 issues, the interest of the HSE in this, the trial by media that appears to go on, and the sort of the reputational damage. But also from the business's point of view, many businesses, most businesses have seen a dramatic negative impact from the crisis. And it's really likely to be a distraction or potentially even derail recovery if you've got costs and management resource tied up in HSE investigations before you even get to the point of thinking about whether or not the HSE seeks to put in place some form of financial penalty.
Yeah, correct. And obviously, we touched on just, the potential from the employees' side and the working environment. But actually, the working environment also, goes back into that managing a safe return to work. I've no doubt there's many people on the line today who, had to reasonably hastily unoccupy their property due to the lockdown. But actually, I think there's issues attached to hastily reoccupying the property as well. I mean, obviously, there's a huge amount of financial implications on business and stress. From the staff members and stress within the management teams about getting the business back up and running. But I genuinely fear that the return to work by many of these businesses could be a little bit too rushed. A little bit focused perhaps on PPE, for instance, which is still the last in the hierarchy of controls, which we detail in health and safety legislation. I say again, health and safety doesn't stop. So. I think I'd probably be saying to people, please check the checks that you would normally check. The maintenance that would normally be in place for your business on a day-to-day entity. Check that they're still being undertaken, still up to date. Legionella is a prime example. It's a killer. The same as COVID-19 has proven. Have you done enough to ensure the health, safety, and the well-being during that recommissioning of your water system? Not in fact forgetting the team that are going to be recommissioning it. All the electrical, mechanical systems, boilers, steam vessels, all these require an element of thorough examination and testing, which is just in line with regulations. And, some of those will no doubt have been due for inspection during the lockdown. And, the guidelines that have been out from the HSE do state that you should still have given access to the inspectors. Now, if you have equipment that, due to difficulties you were struggling to have examined, then, a risk-based approach to ensure they're safe is, an overarching requirement. And I doubt the HSE would prosecute for items being out of that usual testing regime. However, and I think this is the interesting bit, if the results of the failure actually create an injury or cause an injury, then I think you can rest assured that the law is still in place and it will be taken into consideration. And just imagine how a regulator would view the decision not to test a piece of equipment just to the business wanting to get back up and running as quickly as possible.
Thank you, Neil. So from your point of view, we're talking about injury to colleagues and their families, but perhaps not limited to actual illness or even any tragic deaths as a result of COVID, but some of the other forms of issues that come out of it, such as stress and mental health. Action from the regulator and the return to work. And underpinning that, it seems like the fact that COVID is here, COVID is important, it is a risk, but don't forget the broader business risks that you're dealing with on a day-to-day basis, particularly in that return to work. Thanks, Neil.
Correct. Thank you.
So from a slightly different perspective, if I turn to Ben, now it's likely between our speakers there will be an element of crossover in terms of key risks, but I think it's interesting to get the very different perspectives from risk management and two different practice areas of law. So Ben, asking you the same question, in terms of your experience, the conversation with clients and your thoughts and insight, what do you think are some of the key risks for businesses when it comes to litigation that could arise from the COVID pandemic?
Good morning, everyone. I'm going to just touch on three issues. The first is generally the risk of insolvency, and that's a key cause of directors and officers complaints. Secondly, I'm going to add to something that Neil's touched on there in respect of injury claims. But first, I just wanted to talk through some general issues for directors and how the general implications of this crisis may well impact on the way directors approach matters, but also how they lead their businesses to avoid claims going forward. So this is obviously an entirely new, it's a highly contagious disease, and it's led to ultimately inconsistent government approaches around the globe. And I think those issues are making it very difficult for directors to respond to the virus in an obviously consistent manner. The virus has caused major travel restrictions, which are imposed worldwide, and that has caused a significant disruption to supply chain, particularly for businesses who are heavily reliant on China, as many will be. But I think it's quite important to recognise that the broad scale of this crisis and the significant reduction in demand for pretty much every business across sector, and whether large or small, means that this is going to impact on all businesses, whether you are playing on an international scale or whether you're even just an SME business. These sorts of issues are going to affect everyone. Now, the Companies Act imposes various obligations and duties on directors, and I think the ones that are really going to be crucial at this point in time are the duty to act with reasonable skill and care and to exercise independent judgment. And as we run through this crisis and as we move out of it, there are inevitably going to be increased scrutiny of decision-making by directors. And the fact that these circumstances are probably some of the most challenging that any business and any directors have faced in many, many years and probably many generations, on its own is going to be no defence. So what sort of things do I think that directors need to be considering? Well, I suspect there's a few key pillars which arise from the running of any business. And so the areas of focus I would have thought are how are directors looking after their workforce? That's something that Andrew will come on to touch on in a minute. How are the expectations of shareholders, and as Neil mentioned, regulators being managed and considered as we move through? What steps are being taken to reassure customers? And how is that supply chain being assessed and protected? And I'll come on to talk about that a little bit shortly. My second point relates to insolvency risk and cash flow. And I think history suggests that the insolvency of companies is one of the highest or the leading reasons why D&O claims happen. This isn't just simply your business to consider as well. Protecting the risks around your supply chain, for example, are going to be very important from the perspective of protecting your own business. So one thing to be considering, and some of you may well have already done this, is to be reviewing all contracts and considering what options you can take, but also proactively considering what options those you are contracting with may take against you so that you're ready to respond. So for example, the enforceability of force majeure clauses. For new orders, as we enter into this difficult time, do your due diligence. Is the purchaser going to be able to pay for this product that is being ordered? Do you need to consider imposing special terms that perhaps you wouldn't have imposed prior to the crisis, so as to increase your protection? And then finally, I just wanted to touch on and follow up on Neil's comments about the risk of personal injury claims. I think, my talk is generally around the D&O risk, but I think this is something that's going to fall to an EL policy. I think an EL policy will respond to these claims. And perhaps the damages awards for many of these claims, as James identified, will either be very, very limited or will be relatively low. And the damages are likely to fall within the excess of many of the companies who are on the line today. And a key question that I've been asked a number of times is causation. And how are individuals going to prove that your business is what caused them to suffer or to contract this disease, given how contagious we know it is? How do we know they didn't catch it on the bus on the way to work or in the supermarket shop last night? Well, we will see this tested, I'm sure, but I think there's a realistic chance courts will take a similar approach to how they take to industrial disease claims, so asbestosis, mesothelioma. And in that respect, the claimant isn't required to pinpoint the exact cause of the disease, of contracting the disease, but simply that the employer caused a material increase in the risk of catching that virus. Now, that's going to be an easier hurdle to overcome, particularly for those key workers who are still required to attend work. And that will then come back to those risk management steps that Neil identified earlier. Also, of course, this may well not be about the injury risk, but rather the mental health aspect, so the psychiatric and psychological damage that this may cause. And that obviously is a rather different causation test.
I know we said we were going to do Q&A at the end, but just to ask you a question, something you said on your second point was about businesses needing to review the contracts they're entering in for new business that they're winning during this crisis and looking at, I guess, financial viability of people that they're contracting with, contract terms, what they're exposing themselves to. In your experience, do you think that firms overall are taking those steps to modify the way they take on new business, or do you think there is too much of a drive on just getting the new business in while perhaps volumes are challenging, or is there another scenario at play?
I think there is an element of that there will be businesses out there proactively reviewing their contract. Now, some of that may well involve seeking external legal advice. That's obviously a spend to the business at a time when cash flow is potentially quite tight. There is also the angle of you don't necessarily want to impose special terms which may put off a customer at a time when those customers perhaps are thinking very carefully about whether to enter into new contracts. So there is a real balance to be struck here, but I think considering that obligation of reasonable skill and care, making sure that the decisions being made are good for the business as opposed to just simply pulling in new orders, that's not necessarily the best outcome for the business if ultimately those orders can't be fulfilled.
And I suppose we all hope that a relaxing of lockdown and a return to volumes is a nice, smooth transition, but we need to be mindful of the fact that there is a chance that restrictions could be relaxed and could be reimposed. We could be back in and out of this situation for some time. So,
yeah, I think.
Sorry, Ben, apologies.
I think that we will come on to it, but I think that management of the return after lockdown is going to be crucial for many businesses. And I suspect that most businesses ought to be considering that now, even if it may well be several weeks away or potentially longer.
Thank you very much indeed, Ben. So, Andrew, I guess we've got to ask you the same questions we asked Neil and Ben, which has to be, from your perspective, legal again, but a slightly different slant, looking at that employment law focus. What do you perceive to be, in your opinion, some of the key considerations or the big issues for businesses as we hopefully start to look at the recovery out of COVID-19?
I think what's really important is to understand quite at the moment why we've not seen many of the actions that businesses took following the outbreak of the COVID-19 crisis haven't resulted in employment-related claims. And indeed, I think it's quite interesting that employment law is often seen as a barrier to business being able to move quickly, when actually, when you look at what many employers have achieved up and down the country, have been the furloughing of large numbers of employees or the agreement of a temporary pay cut without having to undertake significant individual or collective consultation. So it's quite an interesting time. But I think to really understand why we're not seeing disputes at the moment is to reflect that actually the interests of the employees and the employer are perfectly aligned due to a number of really difficult circumstances. And actually, if you, in a nutshell, both employees and employers are prepared to accept an element of short-term pain, because actually we think that longer term, there are more significant issues that we all wish to avoid. But what that then means, I think, is employers need to avoid taking some false confidence, because part of the reasons we're not seeing disputes are that the labour market is non-existent. So where do employees go if they have a dispute with their employer? But also they don't need to show their hand right now. The limitation period for most employment-related claims is 3 months. Now, lots of the measures taken, for example, collectively consulting, for furlough, most people didn't do that. Well, the limitation period is 3 months. Most people furloughed month and a half ago. So employees are still within the limitation period. Now, crucially, what that really means for employers is that I think as we come out of the COVID lockdown period and employers start thinking about the maybe longer term structural changes they need to make in their business, then at that stage, the interests of the employees and the employers will diverge, and therefore the longer term measures that are taken will not only risk creating issues from those steps, but if you're still within that limitation period, you could see employees going back to steps previously taken. So I think it's really, really crucial to plan the next set of measures that an employer is going to take. The other area I think is really important for employers to think about is how the COVID crisis is going to impact on the longer term. Now, there's two subparts to this. I think there's already been alluded to, we're going to see different types of disputes emerge, I think, in the next few months as we return to the workplace. So as we've already heard, there will be employees who've got real, genuine health and safety concerns about returning to work and in the physical environment in which they find themselves working. So I can easily envisage employees bringing employment-based claims. So do they rely on a little-known provision in the Employment Rights Act, which allow employees to avoid being subject to a detriment if they have a genuine and reasonably held health and safety concern, so they refuse to undertake a job? An employer might have said, well, I want to discipline you unless you go and complete this particular task. So I think new types of disputes are prevalent. But I think on a longer term issue, many organisations became virtual businesses overnight. And they did that by necessity. Now, whilst I am hearing a number of people do want to get back into a workplace environment, the longer-term impact of many of us working remotely for a number of months, I think, will spike an interest and in demand for a level of flexibility. So that means, I think, a challenge and opportunities for employers. But opportunities, how can this work for you? What have you seen in the crisis and the remote working that's actually made your business more nimble? Could you reduce your real estate costs by having a smaller office space because you rely more flexible remote working for some or all of the time? But then again, think about the challenges. If people are going to be demanding flexibility, what's really worked for you and what hasn't? I think a lot of people are expressing concerns about the level of teamwork, creativity and collaboration that is, whilst this is a brilliant format, I think video calls, which have become quite in fashion, still don't replicate that close proximity, respecting social distancing, obviously, that we have in terms of when we work in an office space. So planning for your flexibility, thinking about, okay, what flexibility will we want to offer or be seen to offer or would agree? How can we build that into our policies? And do we need to change the employment contract, which for the 20 or so years I've been doing this has said we all work in an office and we work 9 to 5. And I don't quite know that will be the same moving forward.
It's really interesting, Andrew, because in all the three things you mentioned there, be it in the initial response to the crisis, the needs and goals of the workforce and employers being aligned, through to the return to work, through to, as you said, what work might look like going forward. It seems to be a bit of a battle of hearts and minds, and that's something which is very relevant in our risk and insurance world, because whilst COVID is unparalleled in terms of my experience and the experience many have, we can draw some parallels. So if we look at, for example, a large business making large-scale redundancies, you can often see that battle for hearts and minds starts to be lost. The engagement level from the staff slips away, and that can make people more inclined to make claims. And we can see a spike in injury claims and potentially employment practice claims following those sorts of events. Perhaps it's that someone hurt themselves at work a couple of years ago, and they wouldn't normally have put in a claim because that's not the sort of thing they do, but they're more inclined to do that. There might even be a case where someone was injured and they didn't put a claim, but now they maybe want to exaggerate that claim a little bit, or even on the extreme level, people fabricating events and putting in wholly fraudulent claims. And I think if that hearts and minds thing is lost, and that's underpinned by broader financial hardship, they're all drivers that can see a spike in employers' liability and employment practice liability claims. What are your thoughts on the hearts and mind piece?
I think it's absolutely integral at the moment that employers are open and honest with their employees, because I think, well, I've always said, and indeed my clients are probably slightly bored of hearing me say it, that the key to avoiding an employment dispute is to bring employees along with you. And therefore, if you put it in the context of some of the steps that employers are looking at taking right now, they may not like them. The key is that they understand why they're necessary and why you've looked at a range of different options. And even if we're looking at a collective consultation, I think it's incredibly important that employers do explain what really is the driver of why this has to be looked at, but also then take the prudent steps of ensuring they're rigorous in how they comply with what is, when we're talking about collective consultation, where an employer proposes to dismiss as redundant 20 or more employees at any one establishment. I mean, you wouldn't know I've said that umpteen times, would you? But when you're talking about collective consultation, it's quite formulaic. So tick some of the right boxes, but one of the most important points is how you communicate to employees.
And I know we've spoken offline about this, and you've given examples of, whilst there's obviously a lot of risks associated about this, there is also an opportunity for businesses to shine. And whilst we've seen certain firms tried by social media, there's also been certain firms that appear to have really got the messaging right and changed this into something which could almost be seen as a positive.
Yeah, I saw over the weekend that Honest Burger have come out and have been promoting what they're doing to train some of their employees affected by the crisis. The government has also announced free digital skills training. So there's really an opportunity for employers to think about the way in which they respond and react to employees that may hit the labour market at a difficult moment. But of course, how difficult it is depends on the bounce back and the extent to which the COVID crisis has a long-term financial impact. But I think thinking about how you demonstrate to an employee you care, or at least you understand their situation as well as the situation of the company, is key. You won't eliminate all the claims because there's different drivers, isn't there? There will always be an employee that thinks more monetary, or that doesn't understand, or thinks your actions relate to something else that may have gone on or something that happened in the background. But I think what you can try and do is at least do what you can to mitigate all but those types of issues.
Thanks, Andrew. So we've probably got about another 10, 12 minutes before we're going to open it up to the audience Q&A. So I just want to ask our panel, I was going to say a very simple question. This might not be a simple question, actually. What I'm keen to know is, what can people on this call do now to understand what their exposure is and to respond, to plan for it, to mitigate it in some way? And I appreciate it'll be very different depending on what you've discussed in terms of your key issues. But maybe if I go back to the start and put this question to Neil. Neil, given the issues that you raised around the HSE, employee injury, and the return to work, what, in your opinion, should businesses be doing now to understand this exposure and protect their interests?
All right. Yeah. Thanks, James. Well, I mean, health and safety, like I said before, hasn't changed, hasn't stopped. COVID-19 is just something else that we need to, to look at, to be honest. And so, prosecutions won't stop. We need to make sure that actually we're recording the actions that we're taking, and we're regularly updating and clearly demonstrating the actions that we've taken. In simple terms, and some people will be health and safety on the call, and other people won't be. But you must be able to evidence, so far as what they call reasonably practicable, which is weighing up the risk against the trouble, time, and money you need to control it, that you have complied with the duty of care, the general duty of care under legislation. That evidence is in the form of a risk assessment, and that risk assessment must clearly show, from the balance of all considerations, that actually the controls that you have implemented are appropriate. Any further actions detailed will, of course, reduce the risk to as low as it's feasibly possible. It's amazing, actually, the conversations that we've had over these last few weeks with our customers who actually haven't had that risk assessment. They're not seeing it in that same sort of light. So I think that's very, very pertinent. And in fact, one of the questions that I've seen come through has just been to do with a change in the social distancing measures. Ultimately, guidance from any regulator or something like Public Health England is guidance, and when you don't comply with guidance, then you are leaving yourself exposed, I suppose.
Thank you, Neil. Much appreciated.
Actually, James, sorry, can I interject? Sorry, James.
Sorry, Neil, apologies.
Sorry. You probably ought to be asking yourself, actually, how good is your accident investigation process as well? Unless you're under legal privilege, any accident report will be disclosable to the regulator. So if you have an employee that has acted contrary to the training that you've given them, and actually this relates to just as much non-COVID cases as as COVID cases. And actually, you could probably argue that in the current climate, actually, potentially, supervision might be a little bit lighter, or behaviourally, staff out in the usual place and perhaps not as focused. But it's really important that that accident investigation report shows what your policies and procedures were, that, they were aware of them, and, they'd received all the training and refresher training, and you have that evidence that actually, whilst will not fully exonerate you, please don't misunderstand, it will show what your thought process was, and actually, if they have done something contrary or unforeseen going against what you said, then actually, you've done everything that you possibly could. And sorry, I just thought it was a pertinent point to add in.
Absolutely. Fantastic, Neil. Much appreciated. If people can see my eyes darting all over the place, it's because we've had so many questions through on the Q&A, and I'm attempting to sort of glance through those at the same time. So apologies for that. Ben, same question of you. What, in your opinion, should businesses be doing now?
So again, with my D&O hat on, I'd say 3 key points to attempt to protect your position from going forward. Firstly, corporate governance has to continue. The virus isn't going to be an excuse for directors not to hold regular meetings. And in fact, I suspect it is a trigger to hold more meetings. So things like what disaster contingency planning already exists or needs to be drawn up and actioned, but also to be actively evolving as the process continues. Some regulators, for example, the FCA, have made open statements that they are going to actively review contingency plans. And so going back to Neil's point, failure to comply with that may well lead to investigations and potential fines. So it demonstrates how fundamental this is being viewed. And critically, for those minutes, for those meetings, I should say, ensure that you have detailed minutes which are recording what steps are agreed to be taken, what action plans are being put in place, and how they are going to be implemented. Secondly, I would say take care, very great care over public statements you may make. Now, this may well depend on the size of your business, but I've already heard of 2 COVID-related class actions in the US relating to public statements which have been made by listed companies. Now, the US is something of a different beast from a litigation perspective, but very often where the US leads, we will tend to follow. So, for example, there is a class action claim against a pharmaceutical company who announced it had developed a vaccine for COVID-19. Well, that apparently is not the case. And the claim is that that's had the wrong impact, if you like, on the share price. Thirdly, and finally, I mentioned the risk of insolvency earlier. On one point directors may wish to consider is the external resources available to bring in and to assist. Now, that's not necessarily legal advice. It may well be insolvency advice. Seeking and acting on advice can help demonstrate that you acted reasonably in obviously what were very trying circumstances.
Thank you, Ben. Much appreciated. And Andrew, from your point of view, what do you think business should be doing right now?
I think 2 things. Firstly, we are in an unprecedented time. We are moving at pace. We're not going to get everything right. So I think it's really important to be coming up with a set of principles which guide how you react and the measures you're taking in respect of employees. For example, many of the employers that moved to terminate the employment of employees that fell out of the furlough scheme because they weren't employed at the trigger date, so that was originally the 28th of February, then found themselves unable to respond easily and quickly when the government hastily changed their position a week or so later, and to deal with that in a way which address any PR or employee relations concerns. Now, I'm not bashing employers that have had to move quickly. It's just making sure that the decisions you make are rigorous and by reference to some principles that guide how you deal with your employees' relations strategy. It's the way you deal with most complicated employment issues. The second thing is to think really tactically. So far, employers have taken the right risks. They've taken risks knowing that the interests of employees and employer are aligned. But as that diverges, be alive to it. So I've seen more employers look at, well, how do I get employees to take leave during the furlough or the lockdown period so that we're up and ready to go when measures are relaxed? Well, actually, when you're thinking about that, taking holiday can be quite emotive. It's not the best time for people to be taking holiday. There's also the fact that employers have got the right to roll over, or employees have got the right to roll over holiday for 2 years. Do you need to do these things? So it's about thinking tactically. And that point gets exacerbated when you're also thinking about more difficult measures like longer term pay cuts or collective redundancy. But thinking tactically isn't just about negative things. It's about thinking about the behaviours you want to motivate. So a number of clients I've been talking to that are maintaining production facilities that are continuing to work are very concerned both about the health and safety risk of an individual who's motivated financially to be in work, but may also have symptoms of COVID-19. How do you get them to make the right choices? How do you guard yourself? Because actually, if you start having an outbreak, not only does that stop production, there's the health and safety risk, there's the PR risk. I was talking to a client last week that 2 organisations they were dealing with in North America had to shut down production in that environment, and it was disaster from a PR. So actually, it's little things. What sick pay are you paying people? Do you increase it on a temporary basis? You're thinking really hard about how you motivate the right behaviours. So, it's all about thinking tactically, thinking hard, and understanding the environment we're in.
I think there's a lot of commonality between the responses there. I mean, the starting point appears to be risk committees, management teams, boards need to be having these conversations, thinking about how it relates to their particular business, thinking strategically. And there has definitely been an undercurrent of make decisions, make informed decisions, and document. And if you think you've documented, document again. I'm just doing a quick time check. We're on 10:47. We have got the minute silence coming up at 11. What I'm thinking about doing is asking a couple of questions that have come in from the Q&A. We'll do the minute silence, and then maybe try and get to a couple more before wrapping it up. Technology appears to be holding up. I know Neil froze for a moment, but he's back, and the sound quality's dipped a little. But hopefully, we're all still clear enough for you to hear. So first question that we've had in, and I'm not going to say who's sent these in or what organisations they're from, but the first question is a confirmed COVID case classed as an injury or a disease from an employer's liabilities point of view? Ben, do you want to take that one up?
Yeah, I think I touched on this earlier. I think it will fall to an EL policy. So yes, I think it will.
But do you think it will be classed as an injury or a disease?
I don't know the answer to that. I suspect disease, but I am speaking off the hoof, to be honest with you. Okay,
no problem at all. Well, we know who that question's from, so we will pick that up following the call, and we will clarify that. Now, if you just bear me a second, because it's a little bit clunky now as I have to switch screens to get the next question up. Wow. Okay. So let me see if I can read this out. Oh, right. Okay. So given that a significant number, if not all, companies might be seen as being technically insolvent right now, what steps should directors be taking to protect themselves from liability or claims of wrongful trading? A claim for breach of director duties for continuing trading while solvent is still theoretically possible. Ben, sorry, that's probably you again, isn't it?
Yeah, I'm not convinced that the government's suspension of the wrongful trading laws is going to make a significant difference to the way you ought to operate your business during the crisis. And indeed, the government's statement actually said all of the other checks and balances that help to ensure directors fulfill their duties properly will remain in place. So actually, the reforms themselves don't water down the basic duties and the responsibilities I've spoken about today. I just think it is a time where it is even more critical to ensure that you are complying with those duties as you go along. And as I mentioned, one option is, now despite the wrongful trading element, one option is to seek advice around this issue. So if you are concerned about continuing to trade whilst insolvent, there are options and means available to seek advice about that and the potential implications for your business.
Okay, thank you very much. Next question, which is probably for Andrew, but if I've got that wrong and someone else wants to answer, do let me know. So, Andrew, the question here is, if you have a request for flexible working from two different employees, both citing the fact that they're concerned about catching COVID-19. So, for example, they want to work from home rather than using public transport. One is vulnerable and one isn't. How do you deal with this? Are we at a point where we just have to say yes to everybody, or what are your thoughts?
I think one has to break this down. In the good old times before COVID, where you had competing requests for flexible working, you tended to deal with them in the order they came in, particularly if people were asking for competing changes. The ACAS guidance used to say that you could talk to everyone in the same position and everyone would be understanding, but I just think that gave the employers a decision of, do you want to be seen to be bucking the decision, actually putting it to employees to agree it. But in this context, I think it's really important to start with the fundamentals of what flexibility can you actually offer. I think you need to be not assuming that the employee's concerns are necessarily always ones that you can do anything about, because how can an employer really change the commute that people have? You might be able to be flexible about start and finish time. So I think I would start with the fundamental question of dealing with it in your priority, because I think it's difficult for an employer to put a judgment on whose circumstances are more needy than the other. But I think, what flexibility can you genuinely offer? If you have to limit it, then I think it's only, you're going to come up with a strategy in terms of how you're dealing with it. Now, one thing to be mindful of is that certain categories of individual may not only be making a flexible working request, but they could have a right to, for example, reasonable adjustment. So an issue we've seen come up through the crisis is that people with mental health issues who wouldn't be classed as vulnerable under the guidance issued by the government have, in many respects, have asked to be furloughed or to work from home because they can't cope with coming into work. And I think one has to be mindful of those sorts of requests still going through. So I think a sort of a general approach, but also still being able to look at a few specific situations would be my advice.
Okay, just sticking with you, Andrew, because we've had another question in which does seem at your area of specialism. We've been asked, we're unfortunately going to have to make some furloughed staff redundant. When is the best time to do this? Immediately or at the end of the furlough period?
Well, there was a lot of confusion about a lot of issues with the furlough scheme, and to give the government some credit, they implemented something deliberately simply and then had the bunch of employment lawyers all saying, hey, yeah, but how does this quite work? And one of the issues that's only recently become clear is that whether you could actually issue notice of dismissal during the furlough period, and the government's Q&A indicates that's possible. So what that means is not only can you carry out consultation about redundancies before the end of the furlough scheme, you could actually affect the dismissal and get employees to be working part of their notice during the furlough period. Now, there are some circumstances in which that would mean employees would be entitled to full pay during the furlough period, but those are due to some peculiarity. So from my perspective, I think whether you do implement the redundancies now, there's one, you can do it, but it's two, thinking about the art of the possible. So if you have furloughed people, how can you actually carry out consultation? And if you can't, I think it's thinking about well, how disastrous will it be for the financial position of the business if we haven't either started the consultation or effected the dismissals within the furlough period? And for those of you that have been following the furlough scheme, half the reason for the extension was, of course, the extension of the lockdown, but the other half was that most employers that were proposing 100 or more redundancies, which would trigger a collective consultation at 45 days, were reaching the point a couple of weekends ago where they were going to have to start the collective consultation if they wanted to be ready to make the dismissals from the end of the furlough scheme. So I think employers are looking at mass redundancies. If you want to be ready for the 1st of July, so the day after the furlough scheme ends, you've probably got a window of a couple of weeks to start getting yourself ready to begin the consultation process.
Okay, thank you very, very much. We've got 4 minutes until the 1 minute silence. We have got quite a lot of questions still, but I'm aware we said this was going to be till 11 o'clock. Let me see how we go. We will, I think, continue this. I think we'll continue this after the 1 minute silence, but we're not going to be able to get to everybody's questions, I'm afraid, because they are just so many. Neil, just a quick question for you that's come up, or it talks about the risk management and the HSE, and the question simply is, there seems so much. How can we be sure that we're doing everything we need to do when we've got so many other concerns?
Well, yeah, it's a really big question, isn't it? I think fundamentally, it's a validation process that you need to go through. I mentioned earlier about the fact that we've been talking to lots and lots of businesses around even just having the risk assessment in place and that not being evident. So I think it's a validation process. We've been remotely going through our clients' various documentations, policies, procedures, sense checking it, pushing the boundaries a little bit on expectations, just to try and give some comfort, really, that actually they are doing everything that they need to be doing. I think that's all you can really do at this stage, is just keep regularly reviewing that. Good external view, just to the old adage of you can't see the wood for the trees sometimes, as an overview, just to give you that comfort as well, I would suggest.
Okay. Right, we've got 2 minutes before the silence. I have seen a question that's come in, which I'm going to attempt to answer myself, because it's a yes/no question before we do the 1 minute silence, which is, if an employee's family is affected by COVID-19, could we get public liability claims? The short answer is yes, potentially, but it would very much depend on the circumstances and whether it was a result of your actions and what specifically had happened. But it is something that we can pick up with you separately. We've got the message here, and I'll arrange for someone to get in touch with you after the call. Okay, I think we are about to hit the 1 minute silence. So what I'm going to do is suggest that we start it from now, and I will pick back up in a minute. So I think it's important we observe this, given the severity of the key workers that have lost their lives, and we will pick this back up in a minute. Thank you, everybody. Okay, everybody, thank you very much for observing the silence with us. And I think it's really important. And, also to say that when we talk about key workers, we're obviously recognising those people in the health and care sector, but also those people that are working in essential roles outside of health and care to keep the country going. Thank you. So we're going to do just 2 more questions and then we're going to wrap up for today. So I'm aiming to finish in the next 5 to 10 minutes. The next question that I'm going to pull up, bear with me just one moment. Wow. Okay. So these are obviously not my words necessarily, but going forwards, do you see COVID-19 becoming the new PPI on the claims front, i.e. claims companies getting on the bandwagon by whipping this up? It could become an administrative nightmare if that scenario comes to fruition. Neil, I'll let you take that one.
Geez, thanks. Yeah, obviously the potential is absolutely there. I think the administration side of it, however, the correct risk assessments, the regular review of that, not just having it as a static document, obviously keeping your records up to date. I think, yes, there is that potential. But ultimately, if you have, good sets of policies and procedures that are up to date, well implemented, with a good, training and refresher training regime, with that evidence to support that it's being done, then actually the vast majority of these claims, I've no doubt, would come through on the portal, and actually, having that sort of evidence to be able to give to your insurers within the 2-week sort of window of opportunity, I think they'd be able to back quite happily. Obviously, there's no way of ever getting out of that. Ben touched on causation earlier, and it's going to be very difficult to actually prove. So yeah, it's a really interesting one, and who knows the answer in reality. But I think ultimately, if you get your ducks in a row, then that gives you as best chance as you possibly can, I'm afraid. Okay, final question, and I think this is probably directed to Ben. If we can ask our final question of you. In your key concerns, you spoke about injury claims, and we also spoke about claims which might sit more appropriately under the directors and officers policy. Are you predicting a wave of claims in the aftermath of COVID? And now it obviously touches on Neil's point, but I'm thinking more about kind of actions brought against the corporate entity and the directors themselves.
Without wishing to finish on a real low, but I think, and a number of commentators are suggesting that this probably is the sort of trigger for D&O claims. We saw significant D&O claims following the 2008 recession. It is looking increasingly likely there will be very significant impacts for a number of different sectors. And I'm afraid that insolvency element, it does tend to, historically at least, trigger D&O claims. So I think it just demonstrates how important it is to ensure your systems, your processes, your documentation is as sound as you possibly can make it at this time.
Fantastic, Ben. Thank you very much. I think this is probably a really good point to wrap up the session. We've gone a little bit over the hour, but not too much. I'd like to thank everybody that's taken the time to join the webinar today. And I'm blown away by the level of interaction we've had from people. We will follow up. There are just too many questions that people have asked to cover off in this session now. I'd also like to thank our panel, Neil, Ben, and Andrew, for their insights. As I said, this is our first time we've done Talking Risk as a webinar. Hopefully there haven't been too many IT gremlins, but keep an eye on your inbox because we are going to be doing a series of these. The next one we're looking to put on will probably be around mid-May, and it will expand on some of the topics we've touched on today. So whereas today we're looking at the litigation that could arise out of COVID, and naturally some of that has caused us to focus on the return to work scenario. As we start to talk more and more about what return to work may look like, will there be a new normal? What will the new normal be? we're going to be running a second webinar session that's going to focus specifically on the key considerations for boards around that return to the workplace and what it may look like. So thank you all very much for listening to us today. We will send out contact details as a follow-up. If you've got any questions you haven't been able to ask that you want direct to us, please do. And stay safe, everybody. That's it. Thank you very much.
Thank you. Thank you all. Cheers.
Thank you.
Thank you.